I've seen families lose over $500,000 in probate court because they made one simple mistake with their living trust. Hi, I'm Mike Smith with the Estate Planning Guys and Smith Barid LLC in Savannah, Georgia, and today I'm going to show you the 5 most common trust funding mistakes that send your family straight into probate even when you have a perfectly good trust document. Your trust is like this bucket. It only protects what you actually put inside it. In my years as an estate planning attorney, I've watched families discover too late that their trust was essentially empty. Recent statistics show probate costs an average of 3 to 7% of your estate value and takes 20 months to complete. These 5 mistakes cost families an average of $50,000 in probate fees. When you pass away, if your assets aren't properly funded in your trust, your family faces the nightmare of probate during a time of grief. So let me show you how to avoid this. Mistake number 1 is leaving your bank accounts in your individual name. And this is the most common mistake that I see. You create your trust, you sign all the documents, but your checking and savings accounts are still titled to you personally. So when you die, those accounts get frozen and they go straight to probate. The fix for this, go to your bank with your trust document or your certificate of trust, affidavit of trust, and retitle accounts to John Smith, trustee of the John and Mary Smith Living Trust, dated whatever. That takes about 20 minutes and it can save your family thousands. Now, mistake number 2 is not deeding your home into the trust. Your house is probably your biggest asset, but I constantly see people leave it in their individual names. You need a quitclaim or warranty deed to transfer the property into the trust. And don't try to do this yourself. One mistake on the deed creates title problems that cost more to fix than hiring an attorney. Mistake number 3 is forgetting about investment accounts. Your brokerage accounts need to be retitled to your trust. For retirement accounts like IRAs and 401ks, you typically name your spouse first, then your trust as a contingent beneficiary. If you get this wrong, you could trigger massive tax consequences for your heirs. Mistake number 4 is ignoring business ownership. If you own a business, LLC, or partnership interest, those need to be transferred into your trust too. I've personally seen family businesses destroyed in probate because the owner never moved the business interest into the trust. Mistake number 5 is not updating your estate plan after major purchases. So you open a new account, you purchase investment property, you buy some real estate. If these new assets aren't transferred to your trust, they end up in probate. Your trust protects only what's actually inside the bucket. So here's what happens when you make these mistakes. Despite spending thousands on estate planning, your family discovers your trust was essentially empty and they're stuck in probate court for an average of 20 months, paying 3 to 7% of your estate value in fees and court costs during their time of grief. Don't let your family go through this. If you have a trust, but you haven't properly funded it, or you need help creating and funding a trust, call our office at 912-352-3999 or visit smithbarid.com. We'll review your situation and make sure that your trust actually protects your family when they need it most. Remember, a trust is only as good as what you put in it. Make sure that yours is properly funded. I'm Mike Smith from Smith Barid LLC and the Estate Planning Guys, and I'll see you in the next video.